Laying off a large group of employees is, well, usually just a tough day at the office. But in Switzerland, oh, it's a whole different ballgame. A mass layoff kicks off a really strict legal process designed to protect workers. And today, we're going to break down exactly how that works.
So picture this. A company announces it's cutting a ton of jobs. Is that it? Not here. In Switzerland, the law steps in immediately with a whole structured process. But everything, and I mean everything, hinges on one key question. When does a regular layoff cross the line and officially become a mass layoff?
All right, first things first, we need to get the definition straight, because a mass layoff, or Massen and Lassen as it's called, isn't really about why any one person is let go, it's all about the bigger picture.
And here's the absolute key. It's all about the reason for the termination. We are not talking about individual performance here. A mass layoff is specifically when the terminations are for business reasons. Things like economic pressures, a big restructuring, or organizational changes.
And this isn't just a feeling. The law is super specific with the numbers, and they're all tied to the size of the company. For a business with under 100 employees, letting go of just 10 people in 30 days? Boom, that's a mass layoff. For the big players, companies with over 300 employees, the magic number is 30. It's a strict mathematical formula.
Now, this is where things get really interesting. We're about to dive into a detail that is so important it's been argued all the way up to Switzerland's highest court. It all comes down to the difference between a company and an establishment.
So let's break this down. An Unternehmen is the entire company, the whole shebang, but a Betrieb is just one part of it, like a single factory, one office, or a single store branch. And here's the kicker. Those layoff numbers we just looked at, they are calculated per Betrieb, not for the company as a whole. This one tiny detail has massive, massive implications.
Let's look at a real-world case to see why this matters so much. Back in 2021, an employee at Swiss Post got laid off, and she argued, hey, wait a minute, my termination is just one of many happening all across the Swiss Post network. This should definitely trigger the mass layoff rules.
And this put the whole issue right in the spotlight. See, if you treated the entire Swiss Post network as one single establishment, they would have easily met the thresholds. But if her individual local post office was considered its own establishment, well, then the few layoffs there wouldn't be nearly enough.
The court's decision was crystal clear. Each individual post office branch was its own Betrieb because it was a distinct, organized unit. The huge consequence of this ruling, it makes it much, much harder for layoffs at large, multi-location companies to ever legally count as a mass layoff.
Okay, so what happens when a company does hit those thresholds at a single establishment? Well, that's when a strict, mandatory process kicks in. And this isn't optional. It's the law.
The employer has three main duties, and they have to be done in this exact order. First, they inform the employees. Second, they consult with them. And only after that's all done can they officially notify the cantonal labor office.
Step 1 is all about transparency. Employees have to get a formal document in writing that explains everything. The reasons it's happening, how many people are affected, and the planned timeline. This isn't just some casual chat. It's an official record, and a copy goes straight to the government.
Next up is the consultation, and honestly, this is the real heart of the whole process. It's a legally required period where employees are given a genuine opportunity to give their input. The goal isn't just to announce a final decision, but to actually explore alternatives together.
So during this phase, employees can propose other ideas, things like reduced work hours or voluntary buyouts. Now, the employer doesn't have to accept these proposals, but, and this is a big but, they are legally required to review every single one in good faith before they make their final call. So only after that whole consultation process is finished can the employer move to the final step, formally notifying the labor office. This official notice starts a 30-day clock, and no termination can actually take effect until at least 30 days after that notification is filed.
But what about softening the blow for the people who are ultimately laid off? In some situations, there's another layer of protection called a Sozialplan, or social plan.
Now, a social plan becomes mandatory only under very specific conditions. 1, the business has to be pretty large, with at least 250 employees. And 2, the layoff also has to be pretty significant, affecting at least 30 people. If you tick both of those boxes, the employer must negotiate a social plan.
So what's in a social plan? Well, think of it as a package of measures designed to cushion the impact. It often includes things like severance pay, support for early retirement, help finding a new job, or even extended notice periods.
It's basically a financial and practical safety net.
The process is clear, but what happens if an employer just ignores it? Well, the consequences are serious, and they are absolutely designed to make sure companies comply.
Take a look at this number. 2. What does it mean? Well, it represents a huge financial penalty for any company that skips the most important part of this process. Here it is. If an employer fails to do the consultation with employees, any resulting termination is legally considered abusive, and this allows an employee to claim compensation that can be as high as 2 full months' salary. That's a pretty powerful incentive to follow the rules.
But get this, the penalty for skipping the final step is even more severe. If an employer forgets to notify the labor office, the terminations can be declared legally void. This means the employment contracts are technically still active and the company could owe back wages. That is a critical and incredibly costly mistake to make. So when you boil it all down, the Swiss law creates a very clear, structured process. It forces a pause, it requires transparency, and it mandates consultation. It doesn't actually prevent layoffs, but it makes sure they aren't done hastily or without employee input. And that leaves us with a big question to consider. Does this system strike the right balance between business reality and employee protection? That's the core tension at the heart of this law.